I think we can continue anyway. I don't think that's fine. No problem. Mr. John Roberts, please. Good afternoon. Yeah, that would be good if you can stick to that.
From the door advice, I'm trying to put everything down.
Okay, thank you very much.
As much as I can. I live in Oldham, and I'm here today representing the Oldham and Kensington Labour Party. The prevailing winds that cover the area of the proposed site travel across the canal to Oldham and Kensington, then continue on to Chat Moss, Rixton Moss, which are areas of mossland and farming. For years, we've had to tolerate the smell of Davyhulme sewage works. We don't want the alleged pollution from the incinerator. We are strongly opposed to the building of an incinerator in Davyhulme. Thank you.
Okay, thank you very much. Thank you. I've got Mr. Steve Close, and I believe Councillor Morris needs to speak, so she can get away. Is that correct? Yeah, so if you could come now.
Good afternoon, everybody. I'm Margaret Morris, and I'm an assistant mayor in the City of Salford. My previous positions have been chairman of Salford and Trafford Health Authority, and then chairman of Salford Royal NHS Foundation Trust. I'm speaking today on behalf of the City of Salford, although this is a Trafford Council process, and the appeal is against Trafford Council's decision to refuse planning permission. Salford Planning Department did register its objections to Trafford Council in the original consultation, and I think Sir has repeated them to yourself in a letter of the 13th of November. I think our main concerns are poor air quality, as many previous speakers have said, and for Salford residents, the prevailing wind and the pollution that it carries into Salford. We've listened to many articulate speakers this morning, so I'll try not to repeat what has already been said. I think, as I said, I have really serious concerns about air quality and pollution. I live in an area called Brookhouse, which, as many of you know, is just across the Manchester Ship Canal. And we all really do suffer from poor air quality, and as everybody has mentioned, the really offensive smells from the sewage works. We often wake up to find a white dust on our cars in the morning, and we don't know where that comes from. I think, as been mentioned, last Friday there was an incident on Tannock's Road, and we had to close our windows and doors because of the smell. It was really strong, and it stung your chest to breathe. At the time, Salford City Reds, which has also been mentioned, were playing a significant match, and there were up to 10,000 people there. Luckily it was raining, but nobody, as far as I know, has monitored how they were affected by this problem. Salford, especially the ones running along the side of the canal, that is Eccles and Weast, Erling, Cadizhead has just been said, Barton and Winton, have really poor health indices and suffer from cancer in a disproportionate way to the rest of Salford. We have the highest infant mortality in the country. I'm not sure how the weather affects the way fumes travel, but my experience is that we across the canal suffer from the industrial waste products because we live so close, and we suffer with the residents of Trafford Council residents. I myself have suffered from a collapsed lung and pneumonia from an accident spill of bromine in Anglesey some years ago. So I do know that accidental spills happen, and often when the public become aware, it is too late for them to take effective action, if at all, that they can take any. I would ask, sir, along with many speakers today, that you refuse this appeal.
Thank you. you. Mr. Steve Groves, please. Steve Groves, not yet. No, I think actually Michelle spoke to me about it and said that this phrase, sorry, we started without you. I didn't think that would cause you problems. I hope I'm right. Okay, and then Mr. Green up there. Good afternoon, Mr. Green. You did speak for about 10 minutes, or I think more than 10 minutes yesterday, so perhaps if you can
well, I'll make
my request for some brevity.
I'll make a comment on that in that regard, Mr. Chairman. First of all, I was told that I was scheduled to speak, excuse me, at the end of the day, so I've been taken a little bit unawares that you've called me to the chair just at this moment.
Okay, I apologise for that, but you are actually the last person I have on the list at the moment, so effectively it will be the end of the day, or the end of the session.
But are we not running this afternoon as well?
Well, we have no more speakers to hear. I'm going to take views as to whether we might have a brief discussion of conditions without prejudice, but I just want to hear what you'll be saying, and you'll be the last speaker.
Okay, well, first of all, let me say that none of the things that have been, about 90% of what I'm going to say has not been said previously. So I don't have to worry about going over ground.
No, that's fine. But also, I do want you to concentrate on the issues rather. I don't want to.
Indeed, Mr. Chairman.
Have a leisurely review of how the inquiry is proceeded.
Indeed, Mr. Chairman. Yes, I understand that, and I can assure you that there are at least 10 very critical errors that need to be corrected, or critical errors in my view, in order to avoid you reaching a prejudicial judgment.
Okay, well, so, you can deal with them briefly.
Well, Mr. Chairman, all I can say is what I've said to to Michelle, and I said that this is the reason why I said at the beginning of my speech. I've been on this case for 2 years, and in addition to that, I've been at this inquiry every day, as you noted. And during that time, I've heard additional information that's complemented the concerns that I needed to raise with you. And I think we got to the point yesterday where we'd established that you are giving a fair and equal opportunity to the objectors so that you don't reach a prejudicial judgment that favours either party. Did we get to that point, Mr. Chairman?
Yes, I think we did.
Right. Well, in that case, I'll start speaking now, but I have to say that if we reach a point where I'm out of time in some way, well then, I mean, just briefly looking at my chemical engineering colleague over there, Mr. Oathen, who had 3 hours earlier in the week, and then another 2 or 3 hours under cross-examination, I am equally as qualified as he is. And I've got equal concerns to rebut some of the things.
The difference is Mr. Oathen has been called as a witness. I appreciate your qualifications, and I'm not in any way trying to suggest that you're not qualified. Mr. Oathen was called as a witness. BCAG called witnesses, and they were cross-examined. They spoke for a considerable period of time. And Mr. Fraser called an air quality witness. So the issue has been dealt with thoroughly at the inquiry.
Well, I'm not
Well,
I'm not just simply speaking on...
Get on with hearing what
Yes,
you have to
yes,
say.
well, okay, Mr. Chairman, and I'll do that, but I'm sure you, the 10 or so critical points are not just focused on our air quality. They are points that have not been raised whatsoever by anybody else in this room, and unless I say them, they just won't be said. So with your permission, I'll continue and see how far we get. Selective non-catalytic reduction. Under the heading of selective non-catalytic reduction, SNCR, there is a further error as follows. Although the EA permitting regime is a separate administrative process to this one, it remains an inescapable fact that the concerns to which I have just alluded impact directly on air quality, which has been much discussed here. Hence, my reference to the EA is relevant for this reason. In fact, we can go further than this. Learned Counsel for Peel made the point when he touched upon SNCR that it was best available technology and that this was a pollution control issue, so we can leave it there, as he put it. However, this is not a pollution control issue, it is a plant design issue, because the use or otherwise of SNCR has an impact on the plant emissions, which are decided at the plant stage, at the plant design stage, not the operational stage. So I submit that you cannot leave it there, as he said. It has to be addressed. Is this then yet another example of a lawyer making a comment outside his field of expertise? I leave that judgment to you, Mr. Chairman, but again, meanwhile, no offence to the gentleman concerned. These examples should concern you, because if the wrong people are making decisions based upon profit instead of science, we are likely as not to get pollution effects.
You've got 10 points to make, haven't you, Mr.
And this is one.
Mr. Greener. Is this the second point, or is this part of the first point?
Well, Mr. Chairman, I spent a week compiling this statement of case. I can't just dip in here now and zoom into a particular paragraph. I've compiled it in the only professional way that I can. And I'm at a loss if you're going to stop me. I'm going to lose the flow of my presentation if you do that. I don't know what to say to you, sir. I've just come here as a local resident, as a professional person, and as a concerned person. And if I'm being hindered in offering you my evidence, I'm at a loss. Can I not just read what, like the other people have done? I don't know what to say to you, sir.
Can you give me an indication of how long you think it would take to read out?
I think at least 20 minutes.
Well...
And why not?
Okay.
Compared to 3 hours,
Well, 20 minutes I think would be fair, Mr. Greenup, and as I say, you spoke for over 10 minutes last night, so I think 20 minutes would be fair. So I'll ask you to deliver it in that period, please.
And if I can't, Mr. Chairman, does going back to...
Well, I think you can. I think you can.
Well,
you can pick out the key points.
Well, no, I can't, Mr.
And you can submit the paper.
Well, 2 points there, Mr. Chairman. I can't pick them out because it doesn't work like that. I can't magically summarise. Had I been made aware in advance that my time was going to be limited, I would have done this differently. And I would like to make the point in public that I should not be restricted as a result of somebody else's error from not telling me in advance that I was going to find myself in the position I've done.
Can you carry on with giving your evidence?
Sadly, my colleagues have similar examples. I am not alone. So I put it to you, Mr. Chairman, that when you consider the comments that have been made by the general public about their lack of faith in these authorities, this perceived fear has mostly been from people who have not had a technical background. But you can see now from the information provided by someone like myself, who has had a very serious technical background, that their intuition has not let them down and their concerns have real substance. Whilst on this point of perception, Learned Counsel for Appeal made it clear that there has never been a case where a planning application has been thrown out because of the perception of harm, and by implication intimating that this fund should not be thrown out on that basis. However, this logic is flawed, as I will now explain. I am sure that Learned Counsel for Peel knows that there have been many legal cases which have been described as landmark rulings where the media have said they could now set a precedent for others to follow a path that has not been previously available. So it is clear from this short historic look at the legal profession that the idea of a case should be thrown out on grounds of X or Y or Z just because it has never happened before is, may I use the word, balderdash. I now turn to my chemical engineering concerns about the stack height and draw your attention to a graph on page 6 of a Fishery report dated 16th of September 2011. And before you ask me for time to retrieve this report, I have reproduced a mnemonic of the graph which has sufficient enough detail for me to illustrate the point, although the mnemonic does have the reference report quoted on it. So if you wish, Mr. Chairman, I can give yourself and Learned Counsel for Peel copies of that now, so that you can follow what I'm saying.
Now, I think carry on with your presentation.
Well, without the benefit of the mnemonic then. In this report, this graph shows a line which I've accurately represented as the solid line on my sketch. If you look at, for example, the difference between the red arrow and the blue arrow, which represents the extremities of the dashed lines that could legitimately be drawn across the boundary of the data, you will see that there is a difference of 300 on the y-axis between the level of 600 NOx and 300 NOx. Now, 300 as a percentage of 300 is, of course, 100% increase. So, when we have been talking about the level of NOx and trying to decide whether or not an extra 1% is significant or not, whether or not an extra 1% is significant, or does it have to be, say, 5% before it is significant, consider now that we have far more serious things to think about. What I am seeing here are potential variations of 100%. The point I'm making is that any line drawn on a graph like this, where the data is so scattered, cannot be relied upon. But again, more importantly, the chosen line isn't even evenly balanced between the dots. I have pointed out to the Environment Agency that there are about 50% more dots above the line than below. In other words, the line is prejudiced in favour of giving the low 125 figure of NOx, upon which the low stack height is dependent. So whereas everybody else has said the stack height is wrong, just on a comparison of other plants, I am giving you a very clear and categorical technical reason why the figure of 125 is flawed, and thus so is the low stack height flawed as a result. In addition to that, it is clear that they have extrapolated the line on this graph by almost 100% to an area of 11% O2, where the graph has no data. So there are two major reasons why this whole figure of 125 for NOx is in doubt. That there is such a lack of data has been confirmed in one of the letters of support from the Boilermakers, but I will come back to that point, which was raised by Counsel for Trafford. The point to note here is that the Boilermakers, in whom the EA appear to place so much confidence, have broken a most fundamental rule of science in their calculations of this much contested 125 figure for NOx. This means that there is a double flaw with the 125 figure, the line and the extrapolation, i.e. a flaw in the science needed to justify this low stack height, and hence these are my technical reasons for stating that this stack must be much higher for reasons of health and safety based upon science, not just a comparison of other plants as others have said. So in turn, my fears of the harm for this plant, that this plant can do, is not merely a perception of harm, From my position of knowledge, and I doubt that anybody in this room is going to challenge me on the fact that I have done my homework on this, it is a very real fear of actual harm, backed up by my ability to spot such technical flaws. It does follow, however, that the perception of harm from those without a technical background has, along with other technical evidence previously provided to them, turned into a real fear of actual harm many months ago. So it is wrong for this inquiry to continue to refer to it as a perception of harm. Hence, I am able to conclude that in fact the harm goes well beyond a mere perception. I can say it is indeed a very real and actual threat. Also, if you consider what I have said about the graph and other technical matters, it is clear from this that there is confusion within the EA. On the one hand, they are requesting information on which to make their assessments, but when that information is credibly challenged by myself and my technical colleagues, they then say it's okay, the manufacturers will have to comply with the limits we set anyway. Thus, it would seem effectively ignoring the evidence given to them when it doesn't fit with them giving the plant approval. So one is left in bewilderment as to why they bothered asking for the aforementioned technical data in the first place, because it's now got no meaning whatsoever. In the very words of Learned Counsel for Appeal, the precautionary principle should only be used when the evidence is doubtful. It is clear from this that the evidence is very doubtful, and I invite him to join with me in submitting to you that it does indeed apply. So just on the basis of these two examples alone, the NOx values for the stack height error and the graph, along with the arsenic problem, which I mentioned yesterday, I have to advise Learned Counsel for Appeal that the EA appear to have not only fallen well short of anything like a most rigorous examination of the evidence presented to them, but also appear to have overlooked or condoned the breaking of a fundamental rule of science, and this despite the fact that I have told them about it. Indeed, these are but two of many examples of them failing to address valid and sound scientific questions put to them by a technically qualified person. So, in the interest of you getting a balanced view that you need to make a fair judgment, I suggest that at the very least you accept from me the evidence which is on record in the last two emails to the Environment Agency and read them within the content of their lack of answers, proving they failed to address legitimate concerns from someone in a position to challenge them at an equal or higher level of competence. There is one final point about this graph, which is that given the concerns about the credibility of the science behind the figure of 125 for NOx, I did note that the support letters specifically stated that they were quoting 125 micrograms per normal metre cubed, and we should clarify if they are indeed referring to the concentration within the exit stack, which of course will not be at normal pressure. It is standard practice to quote normal metre cubed, but we can no longer be sure, in view of the other inconsistencies, that they have calculated the concentration of NOx at the stack pressure. Of course, since the plant hasn't been designed, as I will show next, we don't even know what the stack pressure is going to be, so there is further cause for doubt about the NOx concentration, even if they do believe they've really quoted normal metre cubed. Under the subheading of plant design, I am happy to agree with Learned Counsel Appeal. We maybe should not get embroiled with the allegedly good control regime of the EA pollution arm of their business, although, as it happens, I don't believe that their pollution regime is good, and Mr. Madden has already given a reason because of the warnings they give to plant management, which allows them to ensure the plant will be
Okay,
within pollution. Well, can I finish the paragraph, Mr. Chairman? I'm halfway through a
But I
paragraph.
have got a note of what Mr. Madden said, so there's no need to repeat
Oh,
it.
well, forgive me, I didn't know that when I wrote this. You understand the timing of this. I'm trying to do the best job I can here, given that I'm trying to hit a moving goalpost, so to speak. Please excuse me, I couldn't extract this out, at will. But the point is, it allows them to ensure that the plant will be within pollution limits on any given visit. I have seen this email, and I have written to the editor of the Chemical Engineer magazine on this, and she has published my letter, reference November 2012 edition, if you want to read it, Mr. Chairman. I suspect my chemical engineering colleague, Mr. Houghton, may already have seen it. The matters which I have raised, however, do not relate to the pollution control regime. They relate to the fundamental design of this plant before it is even built, in order for it to be controlled. In point of fact, I can advise all in this room that in my professional opinion, based upon the information I have seen, there is no plant design of this plant, but rather, as someone in this room has already said, a hodgepodge collection of comparisons of individual elements here and there from Boilermakers who will promise the earth, as Mr. Watson noted in his evidence. I have also made this point to the Environment Agency, who have ignored it, like many of the other things I have said to them. Hence I conclude that the fears of the residents are valid, even though they have probably not come from the level of deeper understanding I have been able to make based upon my professional experience. But said flaws are well-founded nevertheless, and it is therefore almost axiomatic that the alarmist publicity to which Learned Counsel for Peel has referred is in fact probably closer to the truth than is realised. Accordingly, there is indeed a very solid basis to give the perception of harm significant weight. In fact, from my point of view, it is more than just a perception, it is the reality for the reasons I have given. Whilst I have just mentioned Boilermakers, I would add to the point that Learned Counsel for Trafford made about the reliability of the letters of support from the suppliers. In the Andrix letter of support, you will find a comment in paragraph 3 to the effect that plant operational data at the NOx level of 125 is understandably not available due to the hitherto mandated levels being higher than 125. After that, they go on to say that they trust that they can achieve this level, which is not the same as a guarantee, as Learned Counsel for Trafford stated on Tuesday. If one now looks at the Fishner report entitled Further Clarification of Chapter 12 Air Quality, it states on page 7, within the context of how easy it is for the level, for the 125 level of X to be achieved, and I quote, "This is unsurprising as this NOx level is not that uncommon throughout Europe," end quote. The problem we now have is this: if this 125 level is not that uncommon as Fishner have said, why are Andrix saying that there is no data available? None at all. This is yet another example of a contradiction which detracts from the credibility of an ability to give attention to detail needed for designing a chemical plant. I have given Trafford Council Licensing Department copies of my emails to the EA, which refutes some of the science for this plant, science which the Licensing Department said was good, thus leading them to their positive recommendation to Trafford Planning, as Learned Counsel for Peel has said. I asked them the question, have you been able to find any flaws in my rebuttal of the science that you thought was good? However, they have said in an email to me that they won't comment. Now, I am told that there is no legal reason why they can't comment or even revise their decision in the light of new information from me. Someone noted it could be a political reason. If indeed this is true, then what we have is a situation where political incorrectness is once again more important than people's health, and yet another failure has been identified in the system. But there is an even more serious point, and that is this. No matter what the reason is for no comment, we now find ourselves in the position that whilst on the one hand, Trafford Licensing Department can, and indeed do, change their position when they get new information from the applicant, as we have heard in Mr. Olsen's evidence, in order that they ultimately give their approval for the plant. On the other hand, they appear not to be able to change their position when they get new information from a local resident whom the plant will affect and whom is just as well qualified as Mr. Olsen himself. Obviously then, the evidence gathering system we have for a fair judgment relative to the credibility of the technical soundness of this plant via this public inquiry clearly has a bias in favour of the applicant. This is wrong, is it not, Mr. Chairman? You're not making any comment, Mr. Chairman.
I have asked you to focus on your key points rather than rehearse a history of consultations with various departments.
With all due respect, Mr. Chairman,
you have another 15 minutes.
Okay.
Could you make sure that you use those 15 minutes to get your key points across? I'm going to operate a cut-off at that point.
With all due respect, Mr. Chairman, I believe I have illustrated in the last 5 or 10 minutes that the points I'm making are indeed key. I don't know if the people in the audience would agree with me, but I will carry on. And thank you for allowing me to submit my paper. Anything that I've not finished.
As soon as possible. It's got to be,
No, I can do that today. I'm just saying anything that I don't read out, then I can submit it. There is yet another flaw in the system which prevents you from getting what is likely to be a change of opinion from one of the sources which Learned Counsel for Appeal has relied upon and quoted to you as part of his evidence. This is despite the fact that I did note with interest, and by contrast on Tuesday, the 20th, that this public inquiry was able to take on board new evidence at a late stage because Learned Counsel for Appeal, and yet Trafford Licensing can't take on updated evidence to change their mind. So I'm making a comparison there, where there's an apparent double standards, if that didn't become clear. Whilst you are addressing this issue, as I hope you will, what I can do is give you copies of the emails to yourself, and you can judge that the science is good. I try to think of how I, as a qualified technical person, could paint a picture in words of the complicated technical matter in normal language, which could be readily understood by everybody, and what the title of this picture would be. To that end, I would now translate the technical title into normal language as being the British equivalent of a $ with lots of zeros. Put bluntly, profit over health. So in addition, I draw your attention to the fact, and it is a fact, that clearly I have, after a 2-year study on this matter, identified more than one serious flaw in the system which prevents the public from being guaranteed the ability to tease out the pros and cons as the Minister of State said we should be able to. And indeed, Mr. Chairman, this is not in my script, but that is what I am trying to do now. Follow the remit put by the Minister in an address to Kate Green, my Member of Parliament. And also not on this script, I've made you aware that I'll be doing a follow-up report to the new Minister of State. And that report will contain such matters that you don't want me to refer to here. Alleged carbon neutrality. Turning now to the climate change and CO2 levels that have been key elements here and have been referenced in the Statement of Common Ground and noted as a key part of the government policy which has brought this proposal into being. Hence, if there are any flaws in alleged carbon neutrality upon which this proposal depends, then they are relevant, and sadly there are indeed flaws in the alleged claims for carbon neutrality. As part of my more recent research, I have had conversations with the Office of Committee for Climate Change, the OCCC, who advised the government on carbon neutrality, and I asked them the following question: what is the amount of CO2 generated from the various biomass fuels, including wood, per mass of wood burn, per unit of power generated in absolute terms, and also in relation to coal or gas, which is not designated as carbon neutral? Their answer was, they don't know. So when I put it to them that the concept of carbon neutrality could not therefore be scientifically judged because they don't have a figure to work on to do the chemical mass balance, they simply said that they have a target figure that needs to be achieved, and if plants need to achieve this target figure for carbon neutrality to work. However, there are two problems with this approach. One is they were not able to confirm that the current modern, well-managed, well-run incinerators and biomass plants were actually achieving that figure, despite being modern. But they did say that they have reduced the target figure anyway, thus making it more difficult to achieve. Bad though this is, it pales into insignificance compared to the fact that they have no way of knowing if the target figure is correct in the first place. Clearly, and I'm sure Mr. Otham will appreciate this, they must have done a chemical mass balance like I would have done, but they are using a figure which is not known to be correct. Conversely, other information that I have obtained from the States is that in fact wood is 3 to 5 times worse than coal, for example, in terms of the CO2 it produces per mass of coal burn per unit of power generated. The plant operators don't have any control over this figure. It is dependent upon the chemistry of the wood, not the design of the plant. So carbon neutrality has got something of a big problem. I am still pursuing this matter as part of my own research, but clearly it is now an issue for yourself, and I would give you what assistance I can, should you want me to do so. So whilst on the one hand, it may not be within your remit to point out flaws in the government's case, I would hope that it is within your remit to tell the Minister that this flaw has been pointed out to you as part of the job he's employed you to do in taking evidence in this inquiry. Of course, that said, it is surely within your remit, it is surely within the remit of the said Minister, Secretary of State, to reassess the matter, given that he'll then know that the very people advising him, i.e. the OCCC, don't know themselves. In any event, it would appear to be well within your remit to question the relevant authorities about the data that supports the assertions that Learned Counsel for Peel felt this same question was indeed relevant to this inquiry when he asked Mr. Singleton on Wednesday, is there any data in the DEFRA report to the European Commission to suggest that DEFRA are wrong? So the point I'm making there, Mr. Chairman, is that I'm only mirroring what Learned Counsel has done in querying data. So therefore, if it's legitimate for him to do, I presume it's legitimate for me to do. Process control in the real world. Under the heading of process control in the real world, the reports and alleged assurances that I have seen do not convey any of the aspects which would be brought out and thought through from someone who has had process operational experience, POE, as distinct from having a chemical engineering degree, to be able to design the plant, compared to the ability needed for actually running it. I can comment on both of these things because I have done both of these things and have the appropriate direct hands-on experience that goes with that qualification and knowledge. For example, the reports speak in terms of it will give a figure of X milligrams per normal metre cubed of NO2, almost as though that figure were cast in stone, so to speak. There is no perception within the report of accommodating variations or fluctuations within the process for the plant as a whole. No mention of a well thought out and integrated control philosophy across this complete unit in its own right. Indeed, this is not surprising because I have not even seen a plant design at all, as I have said above. And I have also pointed this out to the Environment Agency, who have failed to comment. I have actually worked on and operated process plants with burners and furnaces and with catalytic converters. I have worked in a control room where the objective was to control furnace temperatures to within plus or minus 5 centigrade degrees at elevated temperatures to achieve a minimum pollution output in the airborne stack. I understand the fluctuations which occur in such processes. What we have in this example of a biomass incinerator plant is a need to control, among other things, a level of NOx to a relatively fine and low tolerance. The report by Fishner, further clarification of Chapter 12, for example, speaks in terms of the figure or a figure which is achievable, almost as though once it is obtained, it will stay there for the entire shift or all week. There is nothing in their report to convey an understanding of the variations that the process operators encounter in the real world of chemical processing. The reason I am outlining these points above, which in themselves may only be moderate examples, is to make the point that we have to regard this operation as though it were a living and breathing process subject to constant variation and fluctuation. But sadly, I am alarmed to see that it is being regarded much more in terms of some electronic model with some definitive single-valued and constant output, which of course it is not. I note with all due respect that I see no sense of any perception by the authors of the relevant factors in this report, and certainly no sense of any attempts to incorporate them into the assurances which are being offered. Have any of them had the hands-on process operating experience from which point I am now making these comments? I also have a concern about the way in which they speak about the assurances given to them from the boiler suppliers about how plants work, since this is second-hand knowledge. By comparison, the information which I am expressing here comes from first-hand knowledge, not borrowed from somebody else. I've actually operated and run plants. I've actually been in the arena and faced the bull head-on. Under the heading of air quality, I would add that, and there is a section I will skip here because it's just a quote from an air quality remit.
Okay, well, we're coming up to 2 o'clock.
Okay.
I'll ask you to stop then.
Well, Mr. Chairman, may I just go, if you're stopping me, may I now go to just to the end of this thing? I want to just read a short legal statement for my benefit.
Okay, sure.
It's 4 lines now. But in view of what you've warned people and a number of times, I may, and I think I've got the right paragraph here, Alicia. I may well have raised questions about competence, but that is all I have done. I have not directly or indirectly, maliciously accused any individual. I am entitled to raise questions about such matters, and I wish to make it unequivocally clear that if I have gone that far, I have gone no farther. That said, I would far sooner find myself in a courtroom with a hole inside my bank balance than in a coffin with a nanoparticle inside my lung. Thank you for your time, Mr. Chairman, and I appreciate that you've taken the rest of this submission, which I've not been able to read out of me, which I'll leave with Michelle. And indeed, since my research is going on, I would be so bold as to suggest any further submissions that I might make in the next couple of weeks.
Well, I won't be accepting anything after the inquiry closes. So, and and to be fair to other parties, I think this should be, this document, I mean, it's a lengthy document, they've got to have an opportunity to see it.
What my document, you mean?
Yeah.
Oh, yes, I can leave that today. That's not a problem.
But, well, I just need to make the point that when the inquiry closes, which is scheduled to be on Tuesday, I won't be accepting anything after that.
Well, okay, that's your decision, sir.
Okay, thank you very much, Mr. Greenham. Okay, now, what I'd like to do is briefly look at the Section 106, which I think will be very brief, and perhaps have a discussion of conditions. I am willing to leave that to Tuesday if that's preferred, but otherwise I'd rather do it now.
Whichever is
Is that
convenient
okay?
for you, sir.
Mr.
Yes.
Fraser?
The only observation I'd have on conditions is, I think last Friday, the agreed position was that we would put a statement in saying what we wanted with our comments on it, and then the appellant was going to have their comment on it. Now, for whatever reason, we haven't received any comment from the appellant that I'm aware of yet.
Okay, well, is it something we can deal with on a round-table basis now? Or
we have got a short written document which we could let you have. I thought we had discussions about.
Okay, Mr. Fraser, you haven't seen a written document. Well, I still think it's probably as well to have a discussion, and then if there needs to be any executive discussion, then there can be. Can I just deal with the and can I make clear for the benefit of the public that there won't be any more speeches today. This is a session to do with the Section 106 obligation that makes certain commitments if permission emerges, and with conditions if a permission emerges at the end of the process. But I do need to say that that's a standard part of inquiry practice. It's not an indication of any prejudgment on my part or any weakening of Trafford Borough's case, but it is a standard part of inquiry. Administrative proceedings, so that there's an understanding of what conditions would be appropriate if a permission emerges from the process. So in terms of the Section 106 obligation, if I can turn to the obligations in Schedule 2, and they're straightforward. First, issue notice by the Council as soon as reasonably possible of commencement and development, and then not to commence development until the highways contribution has been paid to the Council, and that's specified elsewhere in the document. Not to occupy or permit occupation and development until the sustainable transport contribution, again that's specified elsewhere, and to pay the agreed infrastructure contribution together with the monitoring fee. In accordance with paragraph 3 below, and then paragraph 3 sets out agreed infrastructure not to commence development until the landscaping scheme has been prepared and submitted to the Council. And there's a formula for tree planting. So, as far as I can see, that arises from the development, meets the tests of the civil regulations. So I'm just giving an opportunity, Mr. Fraser, you can see this document before.
I haven't actually been responsible for it.
You have it.
I don't understand it to be an issue that's taken by the Council.
But I understand it's agreed.
It is, and the contributions have been calculated in accordance with the Council's adopted supplementary planning document, which itself would be checked for civil compliance.
Okay. Well, I'm happy to leave it at that as far as the 106 obligation. Okay. Thank you for that. And if we can turn then to the conditions. There are draft conditions in the Statement of Common Ground, which I have also in a document that was given to me on the 21st. so that's the day before yesterday. I assume they're the same, the draft conditions.
Yes, the only variation is the list of plans at condition 2 in the written document. It needs correcting to the list of plans in the statement of common ground. And that can be done in advance of Tuesday so that you don't have to do that yourself. We will arrange for that list to be amended in the written list, which will then be emailed to you so that you've got it electronically in a correct form.
That's very helpful, thanks. So the ones in the statement of common ground are correct?
That's the list of plans is correct. The list there is otherwise correct.
Well, that's very helpful. Then then there's another document which is suggesting additional conditions that's been put forward by the council. Again, that was given to me on Wednesday. And the first issue concerns the length of time, condition 1, the length of time allowed for commencement. So the normal period would be 3 years, and there's a suggestion that 5 years would be sort of.
Yes, I've got a written note of what we'd like you to have regard to.
Okay, so it does need special
This
justification.
is quite, I have to say, so it's quite an extensive note. Bearing in mind that the appellants have had our observations for a week, I'm going to have to take some instruction.
Okay.
Sorry, I haven't had it.
Well, that's certainly fair, and I'm prepared to leave that till Tuesday.
Well, the note covers the other two suggested, or the council's two suggested conditions.
It does, okay. So there's a suggested condition in relation to air quality monitoring.
There is, and we've provided a written response to that, which I hope you'll find convenient, Mr. Fraser.
I'm sure that
I'd like to
we need to take some instruction.
You do?
Yeah.
I don't think you said about that.
Okay, well, I'm content to leave that issue until Tuesday. If I can just run through a couple of points that I picked up, and they're only minor things to do with wording, so I will in any event look at the conditions in the light of the circular. Again, I say this on a without prejudice basis. The only detailed comments I've got really is with regard to condition 4, I would suggest including, it refers to a scheme of landscaping. It doesn't specifically refer to a timetable for carrying out the work. That's something that it may be implied in the idea of the scheme, but I think
the intention, I think, is that the scheme would include a timetable for implementation, but for good measure, adding the words at the end, any approved scheme shall be implemented in accordance with its terms. Would not be objection.
Not the objection, okay. So I've got, well, there's a number of conditions that the same thing applies. Maybe 5. 5 and 19 are the ones that I've identified. But you know, it's
the same point applies. So from our point of view, we're quite happy if you are not, or if you're in any way troubled with there needs to be an implementation clause, then please just add the standard wording to them. I hope nothing has slipped through, unless otherwise agreed by the authority or anything like that.
Well, that slipped through, and I was going to refer to it.
Well,
that'll come out anyway.
The same process. If you'd be kind enough, I'm afraid I hadn't been
an agreement
myself.
Agreement in consultation with the highway agency.
Well, likewise, all of those you can happily take it. We would have no objection to them being reduced to a lawful form.
Yeah. Well, those are the only comments that I have really, and I think they're well covered by the advice in the circular, so I feel content on that basis. Condition 15, it refers to it should also provide adequate consideration of impact. I wonder if that's slightly vague, could be reworded. adequate isn't telling me what the level.
No, it doesn't. You could take the word adequate out without any harm to the substance of the condition.
And could I just look at